Hello everyone. Today we are going to discuss about certain important topics that have been in news over the recent times, and what I'm going to do. So there would be different topics that we would be discussing in this session today. So I will provide the list of topics in the description of the video. So if there's some topic that you want to skip or some topic that you want to particularly listen to about the discussion on certain topics, you can just go to the description and I'll provide a timestamping there. You can go and use the timestamping and navigate through the video depending on the topics you are interested in or the topics that you want to know more about. Right. So first of all, the first thing, there is something that has been in the news, that is issues with the Global Hunger Index. This has been in news for quite a while. Right. So the context is that for the second time in 2 years, the Ministry of Women and Child Development has rejected the GHI, that is the Global Hunger Index, in which India has been ranked 107 out of 121 countries. So we have got a rank of 107 out of 121 countries in the Global Hunger Index. The first thing that we must note here is the bodies which who releases the hunger index, Global Hunger Index. So that is something that we have to note first of all. So the Global Hunger Index is released by Concern Worldwide and Welt Hunger Hilfe. So this is something that we have to remember. This is important. Now, the GHI, that is the Global Hunger Index, is computed based on 4 indicators. And those 4 indicators are undernourishment, child stunting, child wasting, and child mortality. Child stunting kya hai? Child stunting means low height for age. Right? Child wasting is low weight for height. Right? So child stunting means that for that particular age, the child's height is lower than what it should be. Child wasting means for a particular height, the child's weight is less than what it is supposed to be. Right? And child mortality is death of a child under the age of 5. Right? So these are the 4 indicators that it is based on. So recently, that was about around 15th of October in the PIB, there was an article. So what India is saying is that, what the ministry rather is saying is that this is an effort to taint India's image as a nation that does not fulfill its food security and nutritional requirements. And that it does not really take into consideration a lot of other factors that it should have taken, right? Now, this Global Hunger Report, as I said, is released by Concern Worldwide and Welt Hunger Hilfe, and these are 2 non-governmental organizations from Ireland and Germany. So the issues raised here are that, here what they've said is that 3 out of 4 indicators that are used in the calculation of this index are related to health of children. And thus, these 3 indicators that are just related to the health of children cannot be representative of the entire population. That is one concern that they have raised. The other thing is, there is something here that is being used as an indicator, and that is the proportion of undernourished, that is POU. The proportion of undernourished is used in calculation of this index, or is actually an indicator that is given here. And this is based on an opinion poll that is conducted on a very small population size of just 3,000 people. See, whenever you conduct a survey, the larger the sample size, the better is your data. With such a small sample size of just 3,000 people, you can understand that this is not a correct indication of the reality. Government also says that this report is disconnected from ground reality, and it deliberately ignores the efforts that have been made by the government in the recent times to ensure food security for the population, especially those steps that have been taken during the COVID pandemic. actually lowers India's rank. So India's rank is 107 out of 121. And in that, this has a big contribution to make, that is the population of undernourished. And this population of undernourished, as I said, has been calculated with just using a sample size of 3,000, which is a very small sample size. So what the government is saying is that there have been the questions that have been asked to the respondents in this particular survey, or while computing this global hunger index, do not really take into account the efforts that have been made by the government as far as delivery of nutritional support is concerned, and the efforts that the government has made in ensuring food security has not been taken into account. Especially during the COVID-19 pandemic, the government has taken a series of measures to ensure food security. For instance, the government of India is running the largest food security program in the world. So, during the COVID-19 pandemic, the government in March 2020 had announced the distribution of free of cost food grains to about 80 crore beneficiaries of the National Food Security Act, the NFSA. And this was done at the scale of 5 kg per person per month under the Pradhan Mantri Garib Kalyan Anna Yojana. So government actually went ahead and gave plus 5 kg plus 5 kg over and above the regular monthly supplies that they are entitled to under the National Food Security Act, under the ration, that they are entitled through their ration card. So uske above, government ने 5 kg और allot किया free of cost to 80 crore beneficiaries of the National Food Security Act. So effectively what they did was that they doubled the quantity of monthly food grains that were delivered to the National Food Security Act beneficiaries or the households. And this was done so that the poor, needy and the vulnerable households do not suffer because of non-availability of food grains during the times of economic crisis, that is during the times of the COVID-19 pandemic. However, the government says that these efforts have not been taken into account while computing the global hunger index, and in which India has been ranked at 107. Apart from this, state governments have supplemented efforts of the central government by providing pulses, edible oils on their own. Apart from this, under the Anganwadi services, since the COVID-19 pandemic, supplementary nutrition was provided to around 7.7 crore children up to the age of 6 years, and to more than 1.5 crore pregnant women and lactating mothers. Under the Pradhan Mantri Matri Vandana Yojana, more than 1.5 crore registered women were provided 5,000 rupees on the birth of their first child, so that they are able to provide nutritious food, they are able to have nutritious food during pregnancy and the post-delivery period, and wage support to such women. So these factors, these efforts have not been taken into account while computing or calculating the global hunger index. That is what the government is saying. So the first one, undernourishment, is was done by estimating the proportion of the undernourished, as I said, and the problem here was a very, very small sample size of 3,000. So that is one problem. And then there are problems with the other 3 indicators. So these 3 other indicators, other than the proportion of the undernourished, relate primarily to children. Stunting, wasting, under 5 mortality, these 3 are related to children. And moreover, these indicators are, if we actually perform poorly in these indicators, that is not just because of hunger. Okay, so there have been efforts that have been made to tackle hunger, but then there are other complex interactions that affect these things in particular: child stunting, child wasting, under 5 mortality. And those include factors like drinking water, sanitation, genetics, environment, apart from hunger. So here, the global hunger index is computed assuming hunger to be the cause for stunting and wasting. But there are many other factors that have to be taken into consideration while uh, taking into account the reasons for child stunting, wasting, and child mortality. So just saying that child stunting, child wasting, child mortality is happening because of hunger is not scientific, it is not rational, and thus India or the government does not consider this to be a right measure, and considers this to suffer from serious methodological issues. So this is something that the government has to say, and it is true to a large extent. But at the same time, we have to understand certain things, that there are a lot of policies, there are a lot of schemes that are there for the vulnerable sections of the society. But at times, most of the times, they are not so effective because of the absence of awareness and because of the absence of active involvement of the stakeholders at all stages in the policy process. So these are the issues with the global hunger index. So this is about this topic. Now going to the next. Next is One Health Joint Plan of Action. So if you go to the WHO's website, you will find this particular description for the One Health approach. So what it says is One Health is an integrated, unifying approach to balance and optimize the health of people, animals, and the environment. It is particularly important to prevent, predict, detect, and respond to global health threats such as the COVID-19 pandemic. So remember, this One Health and things like One Water are important concepts, and you better keep note of these things that keep coming in news. Because from the prelims perspective, it could be important, and even from the mains perspective, it could be important. You could think of questions like, what do you understand by the One Health approach, and what role could it play in preventing the outbreak of various infections? So remember, first of all, this One Health Joint Plan of Action is launched by FAO, WHO, and another organization that is named as the World Organization for Animal Health. So these four organizations have together launched this One Health Joint Plan of Action, and this is basically a plan to address the threats, the health threats that exist, the health threats to humans, plants, and the environment. So it takes an integrated approach, and यहाँ पर ये आइडिया है कि हम ह्यूमन हेल्थ को आइसोलेशन में नहीं देख सकते. दिस वाज ऑल इंटरलिंक्ड. ह्यूमन हेल्थ, एनिमल हेल्थ is interlinked, and then that is also interlinked to environmental health. So this becomes the concept of One Health that showcases the interlink that exists between human health, animal health, and environment health. So basically, this is an approach that calls for collaborative efforts of different disciplines. They want different disciplines to come together and collaborate and work at the local level, work at the national level, and work at the global level, so that there can be, we can attain an optimal health for our environment, for our people, and for animals. So the plan of action here in this particular One Health Joint Plan of Action is to enhance capacities to strengthen the health system, capacity building. The other thing is to reduce the risk from zoonotic epidemics and pandemics. And then to also control and eliminate zoonotic diseases. Zoonotic diseases are that are caused by germs that spread between animals and people. So between animals and people. So a lot of diseases originate in animals and then it spreads to people. So through this, they want to reduce the risk from such zoonotic diseases and also focus on neglected tropical diseases and vector-borne diseases. Okay, one very important thing that we have to understand here in this joint plan of action, also it has been mentioned, is that they plan to curb antimicrobial resistance. Okay, this is important. This topic of antimicrobial resistance is also something important. And what we have to note here is this antimicrobial resistance is also known as the silent pandemic. Now, this separately also becomes an important topic for us, antimicrobial resistance. So, you know what antimicrobials are? Antimicrobials, as we know, are antibiotics, antivirals, antifungals. So, these are medicines that are used to treat infections in humans, in animals, in plants. Right? What is antimicrobial resistance? Antimicrobial resistance occurs when bacteria, primarily, mostly viruses, fungi, and parasites, they basically change with time, and over time they do not respond to medicines, and it then becomes more difficult to treat infections, and it increases the risk of disease, and it could increase the risk of death. So that's why antimicrobial resistance is also known as the silent pandemic. So especially for antibiotics, this has become a major concern because there is an alarming rate of spread of what we can call as superbugs. If you've heard this term, superbugs. So these superbugs are basically pan-resistant bacteria, and they cause infections, and they do not get killed with all kinds of antibiotics that we have. They cause infections and they are not treatable with the existing antibiotic medicines that we still have, the antimicrobial medicines that we have. And because of this antibacterial resistance primarily, it has become really difficult for us to even treat common infections. So this antimicrobial resistance is basically a global health threat. It is a global development threat, and this actually requires immediate action. It requires concerted multi-sectoral action so that we can achieve our sustainable development goals. It is in fact a big hindrance to our sustainable development goals. And in fact, WHO has actually declared the antimicrobial resistance as one of the top 10 global public health threats that humanity is facing. This is primarily occurring because of overuse of antimicrobials, primarily antibiotics, and this has led to the development of drug-resistant pathogens. Now, what we here should realize is that the cost of antimicrobial resistance in the economy is significant. It does not just cause death, not just because it causes death, but also because antimicrobial resistance causes longer hospital stays, and it results in illness that requires expensive medicines, and it is a financial challenge to those people who are impacted with antimicrobial resistance. And without effective antimicrobials that are becoming more and more ineffective as the resistance increases, and as more of superbugs emerge, it actually puts a question on the success of modern medicine in treating infections, because it becomes difficult to treat infections that arise during major surgery, during cancer chemotherapy, and it just puts people at an increased risk. This we can also attribute to lack of clean water and sanitation, and also to inadequate steps that are taken when it comes to prevention and control of spread of these microbes. And this results in antimicrobial resistance, increased prescription of antibiotics, antimicrobial drugs. So this is one of the major agendas of when it comes to the action plan in this One Health joint plan of action. So to curb antimicrobial resistance, which is termed as the silent pandemic. And remember this term superbugs. Okay, now this is one thing. Now the other thing is, the other part of the action plan is to assess, manage and communicate effectively food safety risks. And then also to integrate environment and health policies into One Health. So these are things that we can keep in mind. So for this kind of a plan of action, why do we have to take an integrated approach? Why do we have to consider zoonotic diseases and environmental health when we talk about health? The reason being that human health, as I said, cannot be considered in isolation. It depends on the kind of environment you're living in, and it is important that the environment that you're living in is healthy, because zoonotic diseases also get transmitted to people, and then the health of people cannot be treated in isolation to the animal health, and also we cannot treat environmental problems separate from health, because everything is actually interlinked. So an integrated approach is needed. As far as environment, now when we talk about the environment, now because of climate change, there are increasing temperatures are increasing, and in fact climate is changing, weather patterns are changing. So these kind of changes, especially increasing temperatures, support a range of disease vectors. For instance, recently we've seen the rise in cases of dengue. So because of increasing temperatures and changing climate, there is a greater spread of vector-borne diseases that is happening, and it is expected to happen, and this will impact human health and animal health, and all of this is ultimately interlinked. Apart from this, there is also temperature-related mortality that is happening. Because of extreme weather events, because of heat waves, cold waves, all these things that are happening, they are creating more of a problem, and people are dying, and there is there is an increase in temperature related mortality, and it is expected to rise. Apart from this, food insecurity, water safety hazards. So all these factors are there, and that is why we need an integrated approach to deal with health. What more needs to be done in addition to this? See, one thing that we have to understand is that health and climate change are very much interlinked. So one step that needs to be taken is to mainstream health into climate change agendas, into biodiversity agendas, and to fund health-related programs within the UNFCCC. The second thing that could be done is to integrate or to rather include health in when we are doing impact assessment on development projects. So there are development projects, and before the development project is actually sanctioned, there is an impact assessment that is done. So we should integrate health impact assessment in all development project appraisals. The other thing is to have to increase the application of health forecasting tools, of climate forecasting tools, and early warning systems for human and animal health. And this has already been done. This is being done by the WMO and WHO joint office. They do this. They have understood the link that exists between climate and health, and thus they are using early warning systems for human and animal health, and to understand the impact of climate and climate on health. See, to conclude, what we must understand is that health and well-being, cannot be actually sustained on a planet that is polluted, on a planet that is socially unstable, on a planet that is depleted of resources. So we cannot talk about health unless we have a healthy planet, unless we have a proper system in place, unless we have healthy animals around, healthy ecosystems around. So this interface that exists between human health, animal health, and ecosystem is very important. And this linkage has been understood through this, or has been rather recognized by this One Health Joint Plan of Action. Right? So that's all about this one. Next, we take up a topic of GS2 and related to the judiciary. That is decision by a larger bench. So recently, a constitution bench of the Supreme Court unanimously held that a judgment that is delivered by a larger bench will prevail over the judgment or the decision of a smaller bench, irrespective of the number of judges that form the majority of the larger bench. We'll come to that. So before this, we have to understand one thing, that is the term constitution bench. This term constitution bench is the name that is given to benches of the Supreme Court. Benches of the Supreme Court, which consist of at least 5 judges. Judges who sit to decide any case. So at least 5 judges form a constitution bench. And this bench will deal with a question, with a case that involves a substantial question of law that relates to the interpretation of the Constitution. If you remember, or if you read, as per Article 143, the President can make references to the Supreme Court, right? So for the purpose of hearing any reference made by the President of India to the Supreme Court, there is a bench that is formed, and that bench is also a constitution bench. So the Chief Justice of India has the power to constitute a constitution bench and refer cases to it. So it is the CJI, the Chief Justice of India, who constitutes a constitution bench and then refers cases to the constitution bench in those cases that involves substantial question of law that has to do with interpretation of the Constitution, interpretation of provisions of the Constitution, or interpretation of anything that is related to the Constitution. So, exactly do these benches function? See, first of all, the thing that we have to know is that most of the cases of the Supreme Court, majority of the cases, are heard and decided by a 2-judge bench. Generally, a 2-judge bench decides. Generally, a 2-judge bench decides, or a 3-judge bench decides, and hears cases in the Supreme Court. So one important thumb rule is that a bench of equal strength cannot overrule a decision of another bench. For instance, a 2-judge bench cannot overrule the decision of another 2-judge bench. ठीक है, same strength का bench होगा अगर, तो that bench cannot overrule the decision of the other bench. It can just doubt it at best, doubt the correctness of the decision, or bring something to the forefront. So whenever there is a doubt or conflict between decisions of co-equal benches, yani ki benches having the same strength, then what happens is that such cases are referred to the Chief Justice of India. Such cases are referred to the Chief Justice of India, and the Chief Justice of India then constitutes larger benches. So larger benches are then constituted. And then the larger bench examines the question or correctness of the decision, and a majority opinion is given by them. and that becomes the verdict. A larger bench's decision becomes the verdict, and that is binding on the lower benches. So this decision is given by a 5-judge bench. And now this particular decision has to be, there is a doubt or there is some conflict that has arisen. So that will then be referred to a 7-judge bench. So currently the thing is, if the whatever verdict the 7-judge bench gives, that will be binding on the 5-judge bench. It overrules the judgment of the 5-judge bench. So there are certain issues with this as well. We'll come to that. But the positive implications right now of this is that the positives of this are there is stability and consistency. So because this seeks to ensure that there is a correctness in the decision of the court and the decisions of the court, because a 5-judge bench, there are 2 more judges in here in the 7, let's say a 5-judge bench gives a decision and then that has to be called in question. So a 7-judge bench has 2 more judges in it. So it is considered that a bench with more strength is more likely to arrive at the correct decision. So this way we can have a more correct decision. A better informed decision is what is thought. But there is a problem with this. There are certain issues with such a system. Now, if we have a judgment that is given by a 5-judge bench, and then that is referred to a 7-judge bench. Okay, whatever decision the 7-judge bench gives will become the verdict, and that will overrule the decision of the 5-judge bench. But the issue here is, let us say there is a decision, there is a case, and the 5-judge bench unanimously gives a decision, and let's call that decision A. Okay, so this is some decision. Let's say it is about very simplistically punishing a person. The 5-judge bench gives a decision A, and that decision A is that this person should be punished. All right. Now, this case then is referred to a 7-judge bench, and the bench has come to a decision that this person should not be punished, and we'll call that A bar. That is the decision A bar. That is the opposite decision. But this they have arrived at not by a unanimous decision, but by a 4:3 verdict. That is by a slim majority. So let us say these 4 judges here have ruled in favor of A bar. That is, this person should not be punished. So these 4 people have ruled in favor that this person should not be punished. Whereas 3 judges here have ruled in favor of A. That is this judgment, that the person should, let's say that is the person should be punished. Right? Now, so what will happen here? The final decision will be A bar. That is, the person should not be punished. So the decision here will be finally that the person should not be punished. So finally here the decision is opposite of the 5-judge bench. 5-judge bench gave the verdict A, and these people have given, the 7-judge bench has given the verdict A bar. That is, the person should not be punished. But here in the 5-judge bench, say it was a unanimous decision, which means 5:0 judgment, wherein 5 judges had agreed to the decision that the person should be punished. But in the 7-judge bench, there are only 4 judges who have agreed to this decision that the person should not be punished, and 3 of them are of the dissenting opinion, and they say that the person should be punished. So here only 4 of them are of the verdict, have given the verdict A bar. Yet here it overrules the verdict of the 5-judge bench, overrules the verdict wherein 5 judges had agreed to the verdict that this person should be punished. But in the end, what happens? The 7-judge bench has given this judgment wherein 4 judges have said this, and ultimately the person does not get punished, or it overrules the verdict of this particular 5-judge bench. So the only way is to go for a larger bench if this has to be challenged, and then again the similar question can arise there. So now, if such a decision is arrived at, let's say 4:3 majority से एक decision पर पहुंचा गया है, so then this decision can be doubted on the presumption that had the bench comprised of different judges, let's say the bench had comprised of some other judges, say one judge from this previous bench, then this decision would have been different, right? So the outcome might have been different. So this kind of a judgment, so the consequences of such a decision based on the number of judges, that yes, the correctness of the decision would then become a game of numbers than reasons. But the problem is that if we, for a 5-judge bench, if you then go to a 7-judge bench, so this is the kind of problem that arises. So the recommendation that is given here, that has been given, is that there should be a quorum with a break even or a greater majority than the lower bench. So which means that if you have a 5-judge unanimous decision, and that has to be referred to a larger bench, so you should not refer it to a 7-judge bench, but rather refer it to a 9-judge bench. So that what happens, how will you get the majority over here? So यहाँ पे 5:4 की कम से कम majority होगी. If there is a unanimous decision, 5:0 here. So at least there should be 5 judges who are agreeing to it, to the decision that has been taken. In the previous case, what has happened? 4 judges are agreeing to it, rather than the 5-judge bench where 5 judges agreed to it. So this is a problem. So you should rather, the Supreme Court should rather constitute, if a decision of the 5-judge bench has to be questioned, then it should be considered by a 9-judge bench rather than a 7. So that in any case, it would be decided by a majority of at least 5 judges. So that was the thing. Now at this point, let's also understand this doctrine of precedents, the doctrine of precedents. So this doctrine basically refers to a decision that has already been taken by a higher court. So एक higher court का जो decision होगा, that is going to be binding on the lower courts, and at the same time it stands as a precedent to the lower court judgment, and that the lower court cannot alter this judgment that is given by the higher court. So let's at this time keep in mind Article 141. Article 141 basically says that the law declared by the Supreme Court shall be binding on all the courts within the territory of India. So this way the Supreme Court with its decisions sets a precedent. Precedent का मतलब क्या होता है? So precedent is basically a decision that is considered as an example or a rule that has to be followed in the same situation at some other point later on. ठीक है, तो any higher court's judgment acts as a precedent to the lower court. So whatever the higher court says in the same situation, whatever the higher court has said, the lower court will have to follow that the next time it confronts a similar situation or the same situation. So that is a precedent. So the next topic is Lok Adalats. So this is basically an important topic that has been in news, and it was in news recently because around 450 prisoners were freed in Chhattisgarh after Lok Adalats were set up in jails across the state. So this is something that you should actually revise from your static portion. Nevertheless, we'll discuss it here. So Lok Adalats have actually emerged as tools, as good tools for alternative dispute resolution. So Lok Adalat, as the name suggests, means people's court, and it is based on Gandhian principles. So it is basically an old form of adjudicating system that has been prevalent in ancient India, and this has been agreed upon by the Supreme Court as well. And it forms a very integral part of the alternate dispute resolution system, that is the ADR system. And it is a way of delivering informal justice, like informally delivering justice to people. And the first Lok Adalat camp was organized in 1982 in Gujarat. Okay, and it was at that point of time a voluntary agency, and it did not have any statutory backing. But its popularity over time grew, and it was given a statutory status later on under the Legal Services Authorities Act. Right, so the Legal Services Authorities Act 1987. And this act basically made provisions that relate to the functioning of the Lok Adalats, of the organization of Lok Adalats. So, who organizes these Lok Adalats? So, these Lok Adalats are organized by either the District Legal Services Authority or the State Legal Services Authority or the Supreme Court Legal Services Committee or the High Court Legal Services Committee or the Taluk Legal Services Committee. And this is done at intervals that they think fit, and it is done in places where they think it is appropriate, and for areas where these organizations think it is appropriate to set up a Lok Adalat. So let us say one of these authorities, let's say the District Legal Services Authority or the State Legal Services Authority, says that for a particular area we'll organize a Lok Adalat, and so it is this authority that will decide how many number of judges would be there, how many serving judges would be there, or retired judicial officers would be there, and other persons that they think would be required here. So that's what the agency that is organizing it will decide. So generally a Lok Adalat consists of a judicial officer as the chairman, and a lawyer, or advocate, and a social worker as members. So what we can remember here is that the NALSA along with other legal services institutions conducts the Lok Adalats. NALSA is the National Legal Services Authority. So NALSA was basically constituted under the Legal Services Authorities Act of 1987. Okay, and the main aim of setting up NALSA was to provide a nationwide network, to establish a nationwide network to provide free legal services and competent legal services to the weaker sections of the society. This particular act of 1987, that is the Legal Services Authorities Act, was amended in 2002 to provide for the establishment of permanent Lok Adalats, which basically was supposed to deal with cases that are related to public utility services. So basically, as I told you, this is basically an alternative dispute resolution mechanism, and the jurisdiction of this the Lok Adalats be to determine and arrive at a settlement or a compromise between two disputing parties in any case that is pending before the court. कोई भी case अगर pending है court में, उसके ऊपर if they want, the two parties come and they mutually decide to get this settled or compromised or deal with the matter outside the courts, then they can approach the Lok Adalats. And any matter that falls within the jurisdiction of any court and is not brought to a court, so it even before going to the court, you can come to the Lok Adalat and resolve your disputes. Right? But any case that is pending before the court can refer the case to the Lok Adalat for settlement if both the parties agree, mutually they agree कि हाँ ठीक है हम ये जाके लोक अदालत में इसको settle कर लेंगे ये चीज, then the court can refer it to the Lok Adalat. या फिर one of the parties applies for a referral of the case to the Lok Adalat. या फिर इसके अलावा अगर कोर्ट को लगता है कि ये जो मैटर है ये कोर्ट लोक अदालत में सेटल किया जा सकता है, so then it can be referred to the court by referred to the court to a Lok Adalat, right? Now the Lok Adalat takes up cases such as family disputes or land acquisition cases or certain labor disputes or cases related to bank recovery or workmen's compensation cases, in certain cases criminal cases, but compoundable offenses. So compoundable offenses are those that can be reached at a compromise, that can be compromised. That is, the person who's complained can agree to take back the charges levied, but a non-compoundable offense is more of a serious nature, wherein the parties are not going to compromise. So the Lok Adalat does deal with criminal cases also of compoundable offenses, and but any kind of non-compoundable offense under any law is outside the purview of the Lok Adalat. Non-compoundable offenses are outside the purview of the Lok Adalats, which means more serious offenses wherein it is not possible to take back the complaint or it is not possible for the parties to arrive at a compromise. Such non-compoundable cases, criminal cases, are not to be dealt by the Lok Adalats. They are outside the purview of the Lok Adalats. So the powers, as far as the powers of the Lok Adalat are concerned, it is vested with the same powers that a civil court has. It also has the powers to specify its own procedure, how it's going to function for the determination, how it's going to function with respect to any dispute that comes before it. So this and any award, any sentence or any verdict that is given by the Lok Adalat shall be deemed to be like that of an order of a civil court, and every award that is made by the Lok Adalat is going to be final and binding, and no appeal shall lie before it. So if the person wants, and again you want to file a case, you have to separately approach the courts, but you cannot appeal against the so it is said that no appeal shall lie to any court against the award of the Lok Adalat. The benefits of this is that there is no court fee as such, and if any court fee has been paid, that will be refunded if the dispute is settled at the Lok Adalat. So the idea is to lower the burden on the courts, is to introduce flexibility. It is for a speedy trial of disputes, and there is no strict application of procedural laws that happen. So there is more of flexibility that is here, and there is more of an amicable way of arriving at a solution. And because no fees, it is a way for the vulnerable sections to resolve disputes without having to spend a lot of time, a lot of money in hovering around the courts. So at this point, it is also good to take note of this particular article in this context, that is Article 39A. So this was an article that was introduced by the 42nd Constitutional Amendment Act, and it states that the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity. So we see that these Lok Adalats endeavor to achieve this particular objective. So Article 39A is a directive principle of part of the directive principles, right? So this basically here it says, in particular, to provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities, right? So this is something you can just keep a note of, Article 39A. We saw another article before this, 141. So these two articles, it's good to have an idea about the different articles. It can be relevant from the prelims perspective, also relevant to add value to your answers in case of mains, right? So that is it for today. These are the topics that we have that we took up, and we will come up with more important topics as they in the next video, right? And so that's it for today in this video, and hope this video was useful to you. So that's all for now.